Good morning. Welcome to the Hall of Justice for our first day of December oral arguments. I'll call the first case, in re Forfeiture of 2006 Saturn Ion. This is a 15-minute mini oral argument on the application. You may reserve time for rebuttal, but we ask that you keep track of your own time. And you have 2 minutes of a free fire zone, and you can begin when you're ready.
Thank you. Your Honors, under the plain language of the forfeiture statute at issue here, Stephanie Wilson's car was subject to forfeiture only if two conditions were met. First, her car must have been used to transport drugs, and second, that transportation of drugs must have been for the purpose of sale or receipt of those drugs. Even on the facts alleged by the people, Stephanie's car did neither. First, Stephanie's car was not used to transport drugs because, as explained by the dissent below, transporting a drug user home from a drug sale does not constitute transportation of drugs, even if that drug user incidentally possesses some drugs for personal use. Second, Stephanie's transportation of Malcolm Smith was not the transportation of drugs for the purpose of sale or receipt of drugs. At the time Malcolm allegedly had drugs in Stephanie's car, even on the people's version of the facts, the sale and the receipt were already completed. Any further transportation of drugs after that point could not have been for the purpose of a transaction that had already happened. And in any event, Stephanie did not intend to transport drugs. She intended to transport Malcolm. Because both statutory requirements were not met, the statute does not authorize forfeiture of Stephanie's car. The people's argument to the contrary relies on a tortured reading of the statute, effectively reverting it from a statute aimed at the vehicles of drug traffickers to a much broader statute encompassing the vehicles of drug users, and as here, those of their friends or families. This is particularly problematic not only because we have evidence of the intent to target drug traffickers, but also because the Michigan legislature intentionally narrowed this statute and removed the word possession. Under the people's telling of the facts, Malcolm at most possessed drugs in Stephanie's car.
So you started your argument by pointing us to the plain language. And it seems to me both sides are under the interpretation that the transportation has to be for the controlled substance.
That's right, Your Honor.
But I don't see that in the statute. A vehicle used to transport, all right, so quote, used, then later in the sentence, to transport or in any manner facilitate the transportation for the purposes or sale of receipt, for the purpose of sale or receipt of a controlled substance. Where is it that the transportation must be of the substance? There was transportation here to facilitate the purchase of a controlled substance. And so my plain reading of the statute, even though opposing side hasn't made this argument, I don't see where the substance has to be transported. If there's transportation involved, that's the key to me, is the transportation for the purpose of facilitating a sale or a purchase, that's enough. Where am I wrong here?
Well, Your Honor, I would point out the Court of Appeals below also agrees with the people and with our interpretation, but I think—
But we're here now.
Right, the more compelling answer is just that the statute doesn't make grammatical sense if you interpret it as the transportation of people. The statute would be missing a word or words. So it says, used or intended for use to transport or to in any manner facilitate the transportation. The transportation of what? It would be missing a word, the transportation of a person or the transportation of individuals for the purpose of sale or receipt of drugs. And I think the confusion, Your Honor, is that there's a better construction of the statute would have been to include a comma, but you're faced with the choice of, was there a Scrivener's error missing a comma, or is there actually words missing from the statute that Your Honors need to read into them to get to this interpretation of actually transportation of people could fall under the statute?
Is the vehicle subject to forfeiture under subsection F?
The vehicle is not subject to forfeiture under subsection F, Your Honor, and I think the dissent touched on this briefly below, that When you have a more specific provision of a statute, it governs over the general. So we have a specific provision, Section D, that talks about conveyances.
So you disagree with the interpretation of the 1987 Chevy Blazer case?
I do, Your Honor, and I think for several reasons. One, again, that we have a situation where we have a more specific provision specifically talking about conveyances, that we should use that rather than the more general Section F, but also the canon of justum generis. Section F says, things like securities, cash, and negotiable instruments. A car is not in this category of things, so I think that would be another reason to not
Can you use justum generis when the language says including but not limited to? Money, negotiable instruments, or securities?
Yes, Your Honor, I think that canon of construction is still applicable when it's giving examples. The things should be like the examples. But more importantly, perhaps, Your Honor, is that the Court of Appeals below, because the people have not raised that the car is forfeitable under Section F, said we don't need to decide this right now. And I think because there are serious concerns about whether or not vehicles actually are forfeitable under subsection F, this court should decide that issue when it's fully briefed before the court, and not in a situation as here where the parties didn't raise it below and the Court of Appeals said expressly, we're not touching that right now.
Why should we get involved in the case at all when the facts haven't been developed below? This comes to us on a motion for summary disposition, I believe, that was filed before any evidence was taken. Is that right?
That's right, Your Honor, and I think the reason that you should decide it anyway is because this is an important legal question of how broad is this statute. And on a motion for summary disposition and taking the facts in the light most favorable to the people, it still is a crucial distinction of what does that mean? What does that language mean of transporting drugs for the purpose of sale or receipt?
If the facts are taken in the light most favorable to the people, that means we would assume the vehicle was used to transport the drugs for a brief period of time?
I don't think so, Your Honor, because I think the dissent was correct below that what does this mean to transport drugs? I think it implies an intent to actually convey drugs from one place to another. It doesn't just mean that drugs are incidentally moving forward in a car. And I think an analogy to this would be if you're on a road trip and you stop to get a bag of chips and you eat that bag of chips during your road trip and you get to your location. No one would say, what did you do today? Oh, I transported a bag of chips. No, of course you were transporting yourself to a new location, and incidentally you possessed a bag of chips for part of that ride. And this is particularly true, whereas here the legislature actually removed the word possession. So under a reading that's so broad of transport that it includes any time drugs are in a moving vehicle, then that effectively reads possession back into the statute. But even so, if Your Honors do adopt this very broad reading of transportation, where transportation just equals forward movement of any amount of drugs, still we have to deal with this purpose element of why were the drugs being transported. If the drugs were simply being transported for personal use or possession, that is not enough. The statute says for the purpose of sale or receipt of those drugs. And I think, Your Honor—
Counsel, what is your response to the state's argument that the law on this has been settled for 30 years and what you're arguing is a big departure?
Well, that's simply not the case, Your Honor. The state hasn't been able to point to any published decision out of the Michigan Courts of Appeals, or this court, that directly addresses this issue. And if we look to other jurisdictions that are helpful, there are 10 other states that either have or have had forfeiture statutes nearly identical to this one, and the state isn't even able to point to a single one of those states that has come down on this issue in their favor. There are, however, 4 states that we've cited, state high courts, that we think have issued decisions that support our view, and the state acknowledges that 2 of them directly support our view. Particularly the 1977 Porsche case out of Nevada is exactly on point. There we had a situation where somebody was repeatedly going to a location to buy drugs. Sometimes they actually used the drugs in the car, and sometimes they drove away with the drugs in the car. And what the Nevada Supreme Court said is, this is not transportation for the purpose of sale or receipt of drugs. This is just possession of drugs. And because the Nevada legislature, just like the Michigan legislature did, took out that word possession, we're not going to read it back in. And I think, Your Honor, even in a situation where we don't have published cases here in the state of Michigan that are directly on point, we do, of course, have tools of statutory interpretation and canons of construction that we can rely on to help us interpret what this means if your honors find the statute ambiguous. And most importantly, we have the canon of strict construction. After all, this is a penal statute. And the courts in Michigan have repeatedly said that a statute awarding a penalty is to be strictly construed. And before a recovery may be made, the case must be brought clearly within the terms of a statute. Now, the people say we don't need to worry about this canon of strict construction because this is part of the Public Health Code, and the Public Health Code is to be read liberally. But that's simply not the case. In other forfeiture cases, with statutes also part of the Public Health Code, the Court of Appeals has said this canon of strict construction still applies. This is the 8120 Ravine Road case, where there was a question of whether the word container included a house. And what the court there said is we are bound to strictly construe this statute if there's any ambiguity because it is penal in nature and because, again, as courts have repeatedly said, the law does not favor a forfeiture. And so this canon of strict construction is useful here, but it's also crucially important, not only because it puts people on notice of whether or not they're doing something that could cause them to permanently lose their car, but also because it respects the role of the legislature. And it ensures that it preserves the legislature's role as the body that defines crimes and fixes punishments. So I think if your honors do find that there is some ambiguity in the statute here, it's clear that your honors should resolve that ambiguity in favor, or involve that ambiguity in favor of the claimant and against applying a penalty where that penalty's application is ambiguous. And if your honors have no further questions, I'd like to reserve the balance of my time for rebuttal.
Well done.
Good morning, Madam Chief Justice. May it please the court. My name is Joseph Schopp. I'm appearing today on behalf of the people of the state of Michigan. Obviously, the appellee in this case. I think my brief makes clear our position in this case. We basically went through the words of the statute, examining them word by word, phrase by phrase, to basically set forth and elucidate the 5 elements of this forfeiture statute. But I think there's 2, points that I want to emphasize today. One is, I think both the claimant's argument and both Court of Appeals opinions, frankly, focus too much on the first portion of the disjunctive in the transportation element. They focus solely on physical transportation of the drugs in the car from the point of sale to the point of the traffic stop. And while we do, as I argued in the brief, believe that that was enough to fulfill the transportation element, I think we might be missing the more obvious way to fulfill it in this case, which applies to the whole transaction, which is that Ms. Wilson, by driving Mr. Smith to the drug house, by allowing her car to be the site of this drug transaction that occurred, and in the view of Sergeant Rivers, by driving away until the point of the traffic stop, and then whatever in future drive that she intended, but for the traffic stop, she was facilitating the transportation of heroin from the drug dealer to Smith. That was her express goal. She expressed that intention to Sergeant Rivers when he interviewed her after the traffic stop. And that is the more obvious way to fulfill the transportation element of this case, even if this court doesn't believe that the physical transportation is enough to satisfy that element. And then secondly, I want to emphasize, it seems that claimant, in their statement of facts in their supplemental brief, they are basically continuing to assert their innocent owner defense in this case. And while, of course, they would be free to do that at trial, this is an appeal from a motion for summary disposition. The facts must be viewed in the light most favorable to the people. And in that case, that, for the most part, believes crediting Sergeant Rivers' testimony, in addition to some key admissions by Ms. Wilson herself.
Let me just take you back to the last point. You might have provided some clarity for me, but if the only type of transportation that qualifies for forfeiture under this statute is the transportation of the controlled substance itself and not a person, wasn't the receipt of the controlled substance in this case already completed before the transportation began?
So I guess I would say no. And I would say that for two reasons. One, again, I would say the facilitation of the transportation was ongoing the entire transaction. But secondly, I guess the best analogy I could make to this circumstance would be a getaway driver of a bank robbery. The purpose of the getaway driver driving away from the bank robbery after the robbery in the bank itself is concluded is to drive away, obviously, to get to some place of safety. But nobody would say that the getaway driver did not have the purpose of facilitating the robbery by driving away. So the transaction of Mr. Smith coming into possession of those drugs was still ongoing at the time Ms. Wilson started driving away from the scene.
So every person in the state who drives their friend to somebody's house to buy drugs could lose their car?
If they fulfill the 5 elements, yes, and I think that's important. And the one case I think clarifies this, maybe perhaps not in so many words, is the Ford Focus case, which involved I think it was a pizza delivery driver that drove to deliver a pizza, not intending to get into any drug transaction at all. And then the purchaser of the pizza gave her a butt of marijuana as a tip. And then she took it and put it in the car, and eventually she was stopped. While she did end up going to the house and receiving a controlled substance, her intent in going there was not to receive the controlled substance. So she didn't have the purpose of receiving it. Here, by contrast, if in the facts in the light most favorable to the people, Ms. Wilson clearly, from the moment she set out from her home in Taylor to the moment of a traffic stop, her express purpose was to help this drug sale occur between the drug dealer and Smith. And that's what her entire
So
purpose
how
was.
does that argument not basically also just read possession back into the statute? It had to mean something in 1971 when possession was taken out. I understand you have this sort of backup argument about facilitating the transportation. It seems like that's just possession.
So I guess I have two answers to that question. One, I don't believe when the legislature amended the statute, they intentionally were trying to take possession out of the statute. I think what they were doing is just copying the language of the Uniform Controlled Substance Act, which most of the states at least did in part. And secondly, I would point out to the court—
Which doesn't contain the word possession.
Correct, but the one thing I think that they did that I think that is notable here is in Part 3 of the list of 4 exceptions that are to subsection 1D, the first exception is for common carrier, second exception for innocent owners, the fourth exception is for bona fide security interest. There's a third exception that says certain offenses cannot underlay a forfeiture under subsection 1D. In the UCSA, it's all possession offenses, but in the Michigan version, subsection 1D3, it's only possession of certain offenses like LSD and marijuana, not heroin. So the legislature did not copy the UCSA word for word in this respect. There's a material distinction, whereas the UCSA accepts all possession offenses. Michigan's equivalent provision does not exclude
In your opinion,
possession of heroin.
when was the receipt complete?
I would say the receipt is complete basically when the transaction is complete. So
And that
Smith—
occurred prior to her driving away?
I don't mean the transaction as in literally like the handing of the drugs and the money. I mean Mr. Smith, to effectuate his coming into receipt of the drugs, had to go to the drug house and then go back to where he came from. So I would say until he got back to where he came from, the receipt is not complete.
What if he received it and got out of the car and walked away? Would the receipt have been complete?
I would say at the very least, there's case law on this in other contexts, but maybe in the bank robbery context, for example, basically the end point of the transaction is when the perpetrator reaches a place of safety or temporary safety. Obviously, Mr. Smith had no intention of remaining at the drug house after the sale was complete. So at least to some extent, he wished to leave and take the heroin with him, and that's what happened, at least in the light most favorable to the people. So Ms. Smith I basically would ask the court to view the entire transaction as basically the receipt or the sale in this case.
So when did it end? When
Well—
they drove away, when he got back to a house?
Obviously, it was interrupted by the traffic stop in this particular case, but I would say either when he reached whatever his ultimate destination would have been the end of a transaction,
What
or at
about
the very least
when he injected the drugs, would that have been?
I would say, of course, it would depend on when exactly that happened. In this case, we know it happened relatively quickly after the sale was completed, but in a certain case, it might take longer. I would say it's still, even if you injected the drugs right away, there's a certain process or transaction that takes place of going to get the drugs and then leaving. And that whole process is the transaction that this statute is pointed at. And of course, as I listened to Sister Counsel's argument, I had obviously a couple of responses to what she said. There's case law, of course, saying that forfeitures are to be strictly construed because forfeitures are disfavored, but there is just as much case law, if not more of it, saying that says that the public health code is to be broadly construed to effectuate the health and safety of Michigan's citizens. I mean, I would say there's case law that says both of them, even in Michigan. So basically all I could ask, I guess, is for a fair reading of the statute. I guess those two kind of cancel each other out to some extent.
Counsel, the argument seems to be that subsection 1D is aimed at large-scale drug trafficking. What should we make of the other provisions of the other subsections under 1 that appear not to be limited to large-scale drug trafficking? So, for example, under subsection A, the drugs themselves, it seems to me in every case would be subject to forfeiture, even small amounts. In subsection F, anything used to facilitate any violation of this article, that seems to include lots of crimes, not just large-scale drug trafficking crimes, is subject to forfeiture. And in subsection G, any other drug paraphernalia not described in the other subsection. So that seems to be minor items of drug paraphernalia that would be consistent with personal use. So what should we make of those other provisions in connection with the drug trafficking argument?
Judge, I would agree that I think the statute is not aimed just at drug trafficking. Basically, the only history at all that claimant can point to that would indicate to the contrary would be the UCSA's statement of purpose. But of course, the Michigan legislature need not have shared that purpose. They did not say that they did in anywhere in the statute. And then secondly, even if the main purpose of the statute, hypothetically, were to aim at drug traffickers, still, Ms. Wilson's conduct on the date in question meets all 5 elements of subsection 1D. So basically an analogy I could make is, suppose when passing the witness tampering statute in Michigan, the legislature has set out a purpose statement of organized crime has been tampering with witnesses. This law is aimed at stopping organized crime from doing that. That doesn't mean that if somebody that's not in the mob tampers with a witness, they're just off the hook. If you meet the 5 elements of the crime, or in this case, the forfeiture provision, then you are guilty or your car is forfeitable. That's what happened here. Ms. Wilson transported and facilitated the transportation of heroin for the purpose of effectuating the sale or receipt.
Why didn't you pursue forfeiture under subsection 1F?
So there was some disagreement in the Court of Appeals about this. We had raised the Chevy Blazer case as a reason to reverse the circuit court's ruling in the Court of Appeals. The Court of Appeals found that we had not sufficiently raised it. Obviously, we disagree with that, but that was their
your pleadings
ruling.
below reference subsection 1F or only subsection 1D?
Well, the opinion below.
Well, not the opinion, your pleadings.
Oh, our pleadings, I don't think it was a previous prosecutor. I don't think he had actually named 1F in his brief, but he had referenced the Chevy Blazer case in his brief. So at least implicitly, he was arguing that 1F, the Chevy Blazer was a 1F case. He was at least implicitly arguing that 1F supported the forfeiture in this circumstance. I want to get back to one of the questions Justice Zara asked Sister Counsel about transporting what, basically. I would agree to some extent with Sister Counsel that this statute is basically mostly as a consequence of being a very long run-on sentence, a little bit hard to construe in some ways. The verb transportation doesn't have an object directly after it that's modifying what the verb transportation means in this context. Below, the Court of Appeals held that it has to be transportation or facilitating the transportation of controlled substances. And obviously, that's at least a little bit at odds with the Chevy Blazer case. But I would say, at least in this particular case, it's a distinction without much of a difference. Because in this case, the way that Ms. Wilson facilitated the transportation of heroin was by transporting Smith. So, at the end of the day, under either, no matter which object is
I'm not sure I agree with you. I understand what you're saying. If it's the person, I think it's an easy case for you. If it's the drugs and receipt of the drugs, if we don't buy the notion that it starts when the pickup begins and ends when it drops off, I don't see the receipt. To me, the receipt occurred without the use of the vehicle. The transportation with the drugs is after the receipt. So I'm not sure that I agree with you that you'd win either way. And so just following up on that, did you consider arguing that it doesn't require transportation of the drugs, just transportation of a person?
I know the previous prosecutor had, once the Court of Appeals had held that it was transportation of drugs, not transportation of persons, that he had no issue with that view. I think that was in his answer to the application in this court. So I stayed consistent with that. However, I have no qualms with his argument that he made in the Court of Appeals that transportation of persons can apply. Obviously, that's what the Chevy Blazer case held. That being said, I would to some extent disagree that the entire transaction doesn't occur, at least insofar as the facilitation prong is concerned. But again, I think and this kind of goes back to my point about the public health code, the reason that this forfeiture statute makes sense is, and the reason that it's placed in the public health code is because drug houses such as the one that Mr. Smith and Ms. Wilson were patronizing is a problem for the public health. This house is selling very dangerous Schedule I drugs in broad daylight on the middle of a public street. So it makes sense that people that are patronizing this drug house and therefore facilitating its continued operation would suffer some penalty as a consequence of that action. I see I'm out of time, so I would ask the court to either deny leave to appeal or affirm the Court of Appeals. Thank you.
The Court of Appeals below, of course, held that MCL 333-7521 1D does not authorize forfeiture of cars for transporting individuals to drug sales. And on page 57 of the People's supplemental brief, the people say they take no issue with that view. And again, this is because the statute simply doesn't make grammatical sense if it was intended to say the transportation. The transportation of what? And the statute answers that question by saying the transportation for the purpose of sale or receipt of the items in sections A and B, which is here as alleged drugs. Now, the people's theory seems to be that we have some transportation, we have a drug transaction, we have a vehicle, and this is enough if we just look at this broadly to find a violation of the statute. But that's simply not how penal statutes work. If someone drives to a restaurant in a car, has a few drinks, and then gets a ride from somebody else to get home, you wouldn't say, okay, well, looking at this transaction broadly, we've got some driving and we've got some drunkenness, so we have drunk driving. You need the elements at the same time. And just so here, at no point, even under a broad definition of transportation advocated by the people, at no time did Stephanie's car meet all of the statutory elements for forfeiture under this section. At no time was she transporting drugs for the purpose of sale or receipt of those drugs. And the people's argument that she was facilitating the transportation of drugs simply by bringing Malcolm to a drug sale is, again, undermines their position that they don't take issue with the fact that the statute actually doesn't authorize forfeiture if it's merely transportation of a person. Because under this very broad definition of facilitating transportation of drugs, of course, as Justice Welch pointed out, you are, again, encompassing anyone who's driving someone to a drug sale. The people, again, have said they take no issue with the Court of Appeals' view that that is not forfeitable under the statute.
What's your response to my question to opposing counsel about all of these other subsections that do not appear to be limited to large-scale drug trafficking?
Well, what I would say, Justice Viviano, is that we have evidence about subsection D specifically. And that evidence comes, yes, in part from a comment to the Uniform Controlled Substances Act that is addressing this specific statutory text.
But the legislature
And
didn't adopt that language and express it as the purpose of this act, did they?
No, Your Honor, but what I was going to say next is, of course, we also have the fact that the legislature removed the word possession. And I think that that is crucial, because if we're reading that word.
When you're saying they removed the word possession, is that the only change, or did they actually adopt the Uniform Act with lots of other changes? Are you saying they just made a one-word deletion? Because that would be significant if that's all they did.
Your Honor, of course, the statute also changed because they were adopting a version of the Uniform Controlled Substances Act. But again, that Uniform Controlled Substances Act was significantly different than mere possession. It says transportation for the purposes of sale and receipt. And I think that this is still consistent with Your Honor's point that there are other circumstances within the statute in which you could have things subject to forfeiture as a mere drug user. For example, actual contraband. Of course, the state is going to say, even in the case of simply possession or a drug user, the state can take the actual drugs, or the state can take the kind of instrumentalities that you would use to make drugs. Of course, that makes sense. But when you're looking at a situation in which the state is saying, we are authorized to take someone's vehicle, to deprive them of their ability to get around, I think there it would make sense that that particular provision is more focused on the, as the comment to the Uniform Controlled Substances Act says, is more focused on the conveyances of drug traffickers, not the conveyances of the friends and families of, again, just mere drug users. I see my time is up. If Your Honors have no further questions, for the reasons discussed today and those set out in our briefing, we respectfully request that the court grant the application and reverse the decision of the Court of Appeals below. Thank you.
Thank you both. The case will be submitted.